Yeah, so let me straight away share the PPT and it shares. Things. Is the PPT, are you able to see the PPT?
Yes, sir.
Yes, sir.
Okay. Yeah, I hope now it is visible, right?
Yes, sir, it is visible.
Okay. Okay. This is something which we are and sorry for all these problem that happened. I was not expecting the computer to behave like that. So you can see that this is about the role of the judiciary in disaster management discourse. So this is something which we are going to kind of discuss here. So you see that these are some, some kind of statistics that I have picked up, and these statistics are primarily from the EMDDAT website. So you can see that there are like 10,000 natural disaster-induced disasters that have occurred in the 21st century, and in over last 10 years or so, right, 10 15 years, we had like in during this period we have like 1.6 million deaths and then 4,500 billion US dollar damage. And in 2024, whatever EMDAT has certain kind of criteria to be considered as a disaster, and in according to that one, the 393 reported natural disasters happened in 2024 across the globe. And between the last decade, the average annual natural disaster was 371. And of course, not to forget the COVID-19, and which is one once in a century kind of disaster, and which took 6.5 million victims in over 3 years, less than 3 years time. And also, so far, natural disasters and displacements are concerned. In IMDC website, that they have calculated that around 56.5 million Indians were displaced between 2008 to 2023 due to natural disasters. Now, this displacement not necessarily that has happened across the boundary, but of course, internally displaced, these many people were there. Mm. So this is just our latest one, that we had that Goa nightclub fire, and Ditwa, that the cyclone which hit the southern part just only this month. And it's an endless list. Either something is burning somewhere, some other kind of this kind of disasters that are happening. So it goes on and on. Uh, so this is a disaster profile of India. So as we all know that we are a multi-prone, disaster-prone country, third in terms of reported disaster, first in number of affected population, second in mortality, and between 2000 and 2019, there were around 321 natural disasters that have taken place, right? So this is this, and it is always in the first three. In terms of course China is another, and US, they these are the two countries because these are big countries, so often the numbers are very high, right? And when it comes to number, I don't think that we can India, it's hard to beat India. Already we have seen some of the worst natural disasters as well as man-made disasters, that Bhopal, Odisha, super cyclone, Gujarat earthquake, tsunami, then Uttarakhand floods. It goes on. Right, Nargis cyclone was there. So we can't. It's an unending. But why I have very specifically mentioned some of these disasters, because these were very important disasters so far our law and policy are concerned. So they actually like the, for example, Bhopal gas tragedy, and you know that the whole jurisprudence for that. Uh, these three disasters, right? The Orissa, the Gujarat, and tsunami. Particularly the Orissa, there was a code that came in, for a comprehensive big code that came in for the relief and rehabilitation. Gujarat earthquake, immediately after that, there was a disaster management, Gujarat Disaster Management Act, which happened. That was the first kind of disaster management legislation that came up in India, and it was a very comprehensive legislation. Then, of course, following the tsunami, the Disaster Management Act came in. But however, having said all of these things, right, that so far disaster legislation and these kind of things are concerned, it is not that it started with them, right? So we have these famine codes which were in 1880s. Then we know about this Epidemic Diseases Act. In 1999, there were first time there was a high power committee which was set up, and it's very surprising that why we took such a long time for these things to happen, because in between also we have faced quite a few disaster. For example, Marathwada earthquake in 1993, then there was Surat plague. All of these things were happening, but it took a little bit of time to come up with a serious. There was a serious discussion, and things started coming up in form of codes and other things in independent India. So they only suggested a national calamity management act, which was there. So that came up, and also they gave some models for the state acts. Then, as I told you, that there were a few states which came up with acts like Gujarat, Bihar, Uttar Pradesh, that time Uttaranchal. So this also came up. Then, so far this is Disaster Management Act is concerned, it was supposedly drafted during Vajpayee's BJP regime. The bill was passed in 2005. And then one more thing is that there's some places I have seen that there is wrongly it has been said that this act was passed under entry 97 of list 1. That is not the case. The act was actually passed under this entry, that social security, social insurance, employment and unemployment in list 3. I don't know why this was passed there, but in some of the cases, even in articles, I have found out that some places it is mentioned that under entry 97 of list 1 it was passed, which is not the case. Then we have this, of course, once this COVID-19 happened, right after this COVID-19 happened, that March 14, 2020, that pandemic was a notified disaster under this law. And this is the first time after this, during the COVID-19, that this act was enacted pan-India. So it was implemented pan-India only during this COVID time. Now this is the normal kind of disaster management that we generally have seen over the years. So you have the union, the state, and the district, and this is something which has been happening for a very long time. So far, this particular system is concerned, disaster management is concerned, and this is prior to the passing of the Disaster Management Act. Now, after that one, so there is an integrated system. So you can see here that there are national, state, district level authorities with these other bodies which are there under the Disaster Management Act, and that is integrated with the system, with the general administration which existed even prior to this act. Now, one of the things that we have to understand, that sometimes we bring a analogy with our National Disaster Management NDMA, and say, for example, like FEMA, that Federal Emergency Management Agency. So these are very different. Like, for example, if you go to National Disaster Management Authority, so what happens is that they are very few number. I think so far my knowledge goes, there are around 100 odd people who are working with NDMA, right? Whereas FEMA had a staff of like 6,000, 7,000. And now what happens is that once there is a presidential declaration of an emergency, they don't call it disaster, they call it emergency management. So once there is a like a declaration of this kind, so what happened was that the FEMA takes over. So they have like personnel to work on ground, and that's how they do. But in our case, what happens is that whether it is NDMA, SDMA, DDMA, whatever it is, that they have to bank on the general administration to actually implement things. This is something which I just thought that I should at least mention once, that the definition of disaster which is there right in that act itself, the 2005 act, and it says that natural man-made causes by accident, negligence, which results in substantial loss and damage to or degradation of environment. So it is taking into consideration the environmental degradation also, and beyond the coping capacity of the community affected. There was a kind of lot of armchair discussion about whether pandemic is a disaster, not a disaster. In my opinion, was that it was always good to call them a disaster rather than not calling them, because if you don't include them as a disaster, right, as a health disaster, so that is even detrimental, right? There is no point in leaving it outside. Now, of course, then the disaster management, that what we understand, and we have to understand that one, that that disaster management should not start with a disaster. It's an ongoing process. Like, for example, you see the roads, the other infrastructure, all of these things, when they are built, they should be built in a way that where they can withstand like floods, like earthquake, like other things. So that's how the whole disaster management is, that you kind of start even before that one, and it's a continuous and integrated process of planning, organizing, coordinating, implementing measures which encompasses all of these stages. So even before the disaster, we have to be prepared for this one. If we always see that it's a kind of a post incident, then we will obviously fail in that one. And in the act itself, there are so many plans and guidelines. There's national plan, state plan, their district plan. These are supposed to be updated annually. And then there are ministries and government departments, they also have this plan. In fact, this national plan itself was not there until the Supreme Court ordered in this Swaraj Abhiyan case that you have to have a national disaster management plan. But the plan itself is it's not easy to kind of implemented. In fact, I have seen some of the state plans. Like for example, in my book, I have mentioned a lot of things from a Assam disaster management plan, particularly in terms of their district level also implementation and all of these things. At least they are very good on paper. Right? They have taken very nuances that what are required in a disaster management. But when the disaster comes, that disaster management becomes disastrous management, and that becomes another story altogether. So we are not getting into that one. And you'll find that even on NIDM website also, there are 30 different guidelines which are related to different disasters. So there are too many plans and policies that are there. And one of the thing that which I realized, because I have done some field work in Assam, in Uttarakhand, and all of these things. So it boils down to this district disaster management authority. See, they are the first responders, but the district disaster management authority is the weakest of all of these things. If you look at that act itself, so there are I'm not immediately able to recall, but there are 30 odd duties that is being some 28 or 29 or 30 odd duties, functions that are given to the DDMA. But the DDMA neither have manpower, nothing. Right? If you go to any DDMA for that matter, I'm hoping that Odisha might be a little better compared to other places. If you go to these DDMAs, you will find that there is barely any staff. There is one officer who is taking care of things. Right? It is supposed to be the district collector, but district collector have designated somebody else to be a district disaster management officer, and that fellow is, you will find that probably not even a full-time employee. So that's the kind of things that I have seen. So I just wanted to give an introduction to all of these things before I jump into the role of the courts, that what they have done. Now, am I audible properly?
Yes, sir.
Okay. Now let us come that what the Indian judiciary has done. So we all know that all of these cases, that so many fundamental rights cases we have been learning for all these years of law, how Article 21 has been expanded, all of these things and through this judiciary has earned a lot of name and fame right over the years. This for doing all judicial activism, whatever it is, right? But what has happened is that so far the disasters are concerned, there has not been that much of work done. Means in this area, that is very very limited. Now means all the time we are talking about that either MC Mehta, right, that absolute liability, or the Bhopal gas tragedy, right, which itself is a judicial tragedy, right? So we have been we have been learning about these things. Not much has evolved as a disaster management jurisprudence. And I'm not trying to equate with environmental jurisprudence. Just leave that apart. So I am talking about a specialized area within this environmental law domain. Now, what happens is that most of the thing, there is an ex gratia compensation. So that happens. It also depends that what is the interest of the government. Is it an election year? Is it post election? So all of these things. So because of this one, right? So there is not much of things that has moved in so far the law and policy is concerned, and that's why it I think it is important. There's a very interesting book I must suggest you people to look at this book. I have a copy of it. It's Flirting with Disasters. So this is a book of case studies. So they have taken a lot of case studies from Apollo to Katrina to some other disasters, all of these things. And the point that the authors were driving home is that all these disasters, right, whichever disaster that you talk about, all these disasters, there is nothing called natural disasters. All of these things starts with some falling of some human. So there is always and they have nicely called them organizational bystanders. Now what are these organizational bystanders? Means they are trying to say in all these disasters there is somebody who must have done something which is not supposed to do, or who has not done something which was supposed to do, right? So his inaction or action might have caused this disaster. That was the starting point. Like for example, I will give you some examples. Even in terms of natural disasters, there were kind of warnings not being given properly. So a lot of things that has happened in that way. Now then of course let us once go back to that famous case of MC Mehta, right, Sriram gas leak case. If you see that case, that there is one place which it says that that the compensation must correlate to the magnitude and the capacity of the enterprise, because such compensation must have a deterrent effect. The larger and most prosperous is the enterprise, the greater must be the amount of compensation, which is a nice thing, right? Which is absolutely means it should act as a deterrent. But unfortunately, over the years, this particular ratio or the judgment of this one, that why they should pay and all of these things, it has not being played out in many of the subsequent disasters that has happened, right? I will discuss in the subsequent slides. And even in this one, even in this Goa disaster, already Siddharth Luthra is defending the those people. I mean, I'm not trying to say that no, you should not have defended it. Again, the same plea is coming up, right? That they were not responsible. There is no vicarious liability. They were just sleeping partners. So in a way that they will get away with, right? And that happened because these are the Luthra brothers who have been responsible here. When we look at some the Ansal's case, right, where there was this cinema hall disaster, the same thing happened, right? In this in Ansal brothers, how the court looked at it. So the measure of compensation, what happens is that the rationale behind this compensation remain unsettled. You look at those compensation cases, you will find that it is eventually what the discretion of the individual judges, right? So there are no guidelines, no rules, nothing of this. Measure of the interest, calculation of the time of interest, so from which day that the interest should be calculated, the day when the first the petition was filed, or the day when the lower court gave the judgment, or is it from the date of appeal when they filed the appeal? What is there? How much compensation would be there? And if you look at the compensation, so it sometimes is 6%, sometimes it is 12%, sometimes it is 18%. So there is no uniformity in that way also. Of course, Bhopal gas tragedy, we cannot discuss disasters and role of the judges without discussing about this Bhopal gas tragedy. So what happened was that in this one, there was a large number of victims. This was something which is again shocking for the Indian judiciary and other the whole system, for us also, that such a huge number of victims, such a mass tort claim. So it was something which was kind of first of its kind. So what happened was that there were complexities that involved in claiming compensation, right? And then there was a effort to make an court settlement with outside court settlement with UCC, which did not happen. Even they tried it in the US court. They said that no, is not the right forum. You should go back because everything is there, all witnesses, everything, evidence, all of these things. The incident happened there, so that's how. So say sent it back. Right, and then what happened was that this 1985 this law was passed, and which gave the government of India an exclusive right to represent the victims or enter into a compromise or withdraw proceedings in the capacity of parents petri, right, in such a mass tort claim. uh, what happened was that after it was, now there is somewhere this judiciary comes there. Once it is rejected by the US court, so what happened was that we started this one. I thank the judge in the district court that at that point of time he had the guts to order an interim relief of 350 crores. Now you have to understand that in 80s 350 crores was a massive amount, right, with which he had ordered. Now, and by the time this Bhopal was happening, all of these things, we already have that MC Mehta case, right? So there was civil revision petition filed before the High Court, MP High Court, right, which upheld the liability, but they reduced that from 350 crores to 250 crores. Now this, the UCC was saying it was too much. Government of India, Union of India was saying it is too less. So they all went to the Supreme Court, and in 1990 they eventually they said that okay, as a full and final settlement of all claims, 750 crores were awarded. The problem, and now the 750 crores, let us not be very happy about it, because the number of victims were in thousands. Right, so what happened was that when there was a and this one, they filed a review petition because there were a lot of victims groups and all. They persuaded the government to file a review petition in 1992. What happened was that the Supreme Court approved that settlement. And when this MC Mehta, because that what was said in MC Mehta, that it should be a deterrent, it should commensurate the size and the financial capacity. So this was raised there. The Supreme Court itself said that no, MC Mehta is not applicable. Why? Because that's a judgment and this is a settlement. So settlement, that precedent is not going to be applicable. In his 1992 judgment, the Supreme Court said, they said, let's not look at that one. So this and then what happened was that this was, there was no reopener clause, and because of this no reopener clause, the they have to be there itself, and this whole battle ended there, right? So whatever, but however, there was a hospital which was established for treating of the victims. Means I think that you must see this web series on Netflix, that Railwaymen. So it gives you some idea that what kind of disaster it was. Almost very true to the incident that was there. Maybe some exaggeration here and there, but the sufferings and other things that were true. And what happened in that particular incident, that was also quite true to the incidents that happened. And what they created an hospital, as you can have written here. So the land be given by the state government, and the operational cost and all of these things will be borne by UCC. So what happened was that in this case, the government of India, they have to obtain appropriate medical group insurance, right, so that the premium can be paid from the settlement amount. But even after that, there were distribution of damages. There were delay cleaning up the contamination site. Even last year also, there was a fight about this one, that this area need to be cleaned up, discovery of documents which revealing defective technology, politics, all of these things. So even today that misery has not stopped. So while I am discussing this one, that I think all of us who have studied tort law are very clear about this one, that this Klaus Mittelbach's case, right, where that the pilot who got injured while diving into an empty swimming pool and got head injury. He was paralyzed. He was there for alive for a considerable period of time, and then he eventually passed away. Right. So they said that in this, why I'm trying to tell you about this one is that absolute liability, and think about the Goa case also. Right, not only Goa case, there has been several fire accident cases which has happened, right, and fires have happened in hospitals also, right. In Kolkata, for that matter, there was an AMRI fire, right. A lot of people got killed, around 90 plus patients got killed, and all of these things. So this is kind of an absolute liability, because we are talking about that if the premises was hazardous, that the respondents are absolutely liable. That's what the Supreme Court said in this case. And they said that if the occupier has a duty to give due warning of any latent defect and conceal danger in the premises of which he is aware of, right, which is there in the Easement Act also. So it is already well settled in 1997 by this particular judgment. In fact, in UK, there is a Occupiers Liability Act which we don't have. So they have 57 Act, and then 1984 there was another act. However, this particular liability has not been employed in mass disaster cases, and that's what you see, that we will come to this fire accident cases, and we'll see this one, some cases subsequently. They did not apply this one. Then of course there's a Lata Wadhwa case, Lata Wadhwa versus State of Bihar. This is a case where they formulated a multiplier method. This is a better example, I must say, because this happened in Tisco. There was a function that was there, and there was a fire, and there were 60 deaths. Most of them were employees and family members of the employee. And at that point of time, Tata probably wanted to have a goodwill intact, right? So they gave this good amount of compensation to this one. And the multiplier method which was evolved in this Lata Wadhwa case, that no deviation from this method is allowed. That's what they say. So the court took into account what is that the percentage of burn, daily expenses, cost of medical treatment, expenses for psychotherapy, physiotherapy, effect on marriage prospects, because there were a lot of girls who were burnt case, so that could affect their marriage prospects. So I'm trying to tell you is that this Lata Wadhwa case and this fire in Tisco, they took into consideration so many things. And remember, this was again a kind of a mass tort claim. But having said so, there was a DAV fire in a place called Dabwali. This is in Haryana, and this has happened in 1995. So possibly this was means arguably this is the worst fire disaster, where 442 people were killed, and hardly people know about it in our case, right? You ask law students, law teachers, they probably don't know that this kind of things happen, right? So there was a kind of annual function, and the function, what happened was that they had taken a marriage hall on rent, and what they did was that they tied these ropes of that shamiana which was there on top, and one of that was tied very intelligently. Somebody tied it with a electric pole, and so that shamiana got caught fire, and it was a nylon shamiana. So what happened was that once it got fire, so the entire shamiana came down on people. So a lot of victims and other things that happened. So what happened was that this one, there was a 55 crore compensation that Punjab and Haryana High Court had calculated. There was a one-man commission, judge commission, which was set up, and that's how they did this one. So they said that 55% of it will be with DAV school and marriage owners, and 45 to be divided among state of Haryana electricity state electricity board and the municipal committee. Why the municipal committee came in? Because they allowed this marriage hall to operate even without an NOC. So that's how their thing was there. But DAV, again, they said, marriage hall owner said that we don't have any liability because they have not paid us. Only a 6,000 rupees was paid, and that's all. So there were a lot of these kind of things that happened, but the Punjab and Haryana High Court was very strong on this point, and they said, no, you have to pay this one. DAV went to the Supreme Court that no, we don't want to pay this kind of money. So that's how the thing all went up to the Supreme Court, and eventually in 2013 this happened, which is, again, you see that 442 5 crores with all the kinds of other things. So it did not go well. So then what happened was that in this case, what happened, that they were treated in the PGI Chandigarh or AIMS, right? That's what they also kind of considered this one. And mind it, this picture which is there on your screen is actually a victim from that disaster. So I was talking about this one-man commission. So it was Justice T.P. Garg commission, which actually made a very elaborate kind of calculation for that one. 6 categories were created based on age and economic condition. They relied on that Lata Wadhwa case. Now comes this very, very infamous and very unfortunate case of that Uphaar fire, right? So first of all, that the fire accident happened, right, and 4.5 years the trial did not take place, right? The trial did not take place. It was after the High Court told this one that that you have to do this trial, then only they kind of went and the trial started. They were roaming around, nothing was happening, the courts were sleeping, right? So this one, and possibly you people are very young, probably you don't know about this case. So there was a very hit movie called Border. So that was the case. So it's such a big hit that in Uphaar cinema. And you have to understand, in 1997 not many cinema halls around was an AC cinema hall. So now this Uphaar was a little upscale cinema hall in Delhi, right? So what happened was that they have a transformer which was there in the basement. And actually what happened was that the transformer was malfunctioning even on the morning of that day. And then what happened was that there was again a fire in the evening, and that's how this they caught there was a fire. They came through the ducts, and eventually, there were 59 people who actually died, and the courts kind of convicted them for negligence, right? So 304 IPC, that one. So Delhi High Court, what happened was that they did not they and the victims of the Uphaar has been very diligently following it up. In fact, there is one lady called Neelam Krishnamurthy that I know this lady personally, who has been in the forefront of this battle, right? And I must tell you that Neelam Krishnamurthy has written this book, Trial by Fire. Please read this book, right? Although she is not a law person, but she still have written this book, and it's a fabulous book which tells you about how the victims kind of suffer when they take up cases against very powerful people. So that's what happened, and then they did not revise it to 304 part 2. They said no, this is kind of not a case of culpable homicide and all of these things, so they did not allow that one. They upheld the conviction but reduced their punishment from 2 years to 1 year. Now you see how the court is acting, right? 59 victims, right? And then they said that no. And what is the mitigating factor? The mitigating factor is advanced age with no criminal record. They're educated, respectable people of society. Now I am not adding these words, these are actually written in the judgment. Right now, advanced age, why it happened? Because you have been carrying out this case for such a long time, right? Eventually what happened was that the division, when it went up to the Supreme Court, the Supreme Court disagreed with the reduction of the sentences. So there was a division bench, two of the judges, they cannot agree, and they said that there are a fine of 50 crore each that will be put up with two Ansar brothers, right there. Then it went up to a three-judge bench in 2015, and they said that fine of 30 crore, and they legitimized the trading off of the prison sentence with money. Means they said that okay, there is no point in kind of now kind of penalizing them. It is better that they can give a substantial amount of money. And if you read the petitions, listen to Krishnamurti, read her book, they have been time and again saying that we don't need the money. We want to see these people go through a very severe punishment. Right? So this, these kind of judgments, what they have done is that they have kind of gave a sense of impunity. This exactly, if I am Luthra and Siddharth Luthra will take up these points for in the Goa case also, because that has been happening there. So far the civil litigation is concerned in this case. So what happened was that the High Court decision, what happened, they said that the victim compensation to be paid by the owners, MCD, Electricity Board, and the licensing authority. Right. So I'm not getting into the details. So all have there some kind of joint and several liability. So that's what they are saying, that these people have to be made liable. Now, what the Supreme Court did was that he said that you see that the last two, right, that the Electricity Board and the licensing, right, they could have done their duties better, yet they are not liable for the compensation. Why? That as there is no close or direct proximity to the acts of the licensing authority and the MCD, right, and the fire accident which were killed. Now this is hilarious, right? Because what happened was that licensing authority was actually giving means they were not giving a permanent license. They were just they were extending the licenses from time to time without doing any kind of inspection. Now they said that, and they again, that absolute liability, they did not follow that absolute liability. So they took the MCD out, they took this licensing authority out of this question. But however, it is MCD's one also, that MCD is also responsible in this case, right? Because all the NOCs and other things that come from there. And what they did was that, see, in that, because it was a hit movie, it was so what they did was that the hall owners, what they did, they put some extra wooden benches and blocked a hallway. Right. So what they did was that this was there for a very long time, and that is where the licensing authorities work comes in. So what they did was that there was a 2.5 crore compensation, punitive compensation, which was awarded by the High Court. What the Supreme Court did was that they calculated it in a very strict manner. For these many years, these many extra people came, and these are the kinds of, you know, these are the extra money that they must have earned, and whatever they extra money they have earned, so that is the only compensation that they will uh, they will kind of give, right? So what happened was that they halved the victims compensation as well. This was a kind of time where they could have really latched upon this opportunity and have created a very big compensation to be awarded. That could have been a precedent for next disasters to come, but they have let them go very loosely. Now, this is a line that where this Neelam and Shekhar Krishnamurthy has written, that I regret that I have pursued the Uphaar case so vigorously for 19 years. I should have just shot those responsible for the death of my children and 57 others. I would have been pleaded insanity, and by now I would have finished serving my sentence as well. And Neelam Krishnamurthy tells me this one also. She has told me, right? In fact, I was congratulating her in the sense that, she has inspired so many victims to come up. And again, a web series was there exactly by the same name, Trial by Fire, on Netflix, right? Watch that one. And she was telling me that I have told the director, never show me crying, because I don't cry, right? And two of her teenage son and daughter passed away in this fire incident. Then there was another case which was a Kumbhakonam case where 94 children died in a school fire, and these are the pictures that you see. It is in Tamil Nadu. The pictures that you see are actually the victims of that incident, right? So here again there was a criminal liability, and the founders, they were being punished, given life imprisonment, and under several provisions of law 304 part 2. See, this is very different from the Ansal's 337, 338, all of these provisions, and they have also fined them, right? Even they have kind of, which is a very impressive one, that even the engineer who certified the stability of the building, school building, he has been given 2 years of imprisonment. But again, then what happened was that again in 2017, Madras High Court acquitted them, all of them. So again, there was no hope in this case. Here I want to bring you on a case from abroad, right? That Budaeva versus Russia. It's a 2008 case, right? What happened in this case is that there was like 8 people were killed by mudslide, and they said that, you see, it is because of the negligence, because there was no appropriate warning for this one. So in this case, what happened, that the court rejected this claim that they died of unforeseen events. So what they did was that they appealed to the European Court of Human Rights. Once they appealed to the European Court of Human Rights, so what happened was that in that case, the court held, European Court of Human Rights, they held that even in disaster situation, the state has an obligation to take appropriate step, because ultimately it is right to life, which is there under Article 2 of the European Convention of Human Rights. So there was, now you see this one, that you remember what the Ansal's case happened, and here they are saying that there is a causal relationship between the administrative flaws and the death of the victims. The state failed to take reasonable preventive measures under disaster risk reduction, deaths caused due to the negligence of the state, right? This is exactly what I was talking about, that book which was that Flirting with Disasters. The authors have exactly said the same thing there. there are some cases which you can see that of US, right? There is a lot of cases with regard to disasters, right? Like and this one, that Mac Waters versus FEMA, this case is very important. That they were saying that there that providing disaster related housing assistance is a mandatory act, right? And this you cannot do anything when there is something which is mandatory. Means discretionary, you cannot take a sovereign immunity, right? Because you are mandated to provide this one. If you are mandated to provide this one, then you have to do it, and there is no sovereignty, sovereign protection for that one. Again, this Graham versus FEMA, they said that the FEMA assistance programs are for individuals rather than the states. So they have a large number of programs, that different kinds of programs which are aimed at individuals. They said they're not for the states but individuals. Here, one case that I want to highlight is this Gujarat High Court case of 2002, that is Bipin Chandra Diwan versus State of Gujarat. This case, what happened was that it happened in the post Gujarat earthquake in 2001. So this was a PIL that was there, and this was PIL was filed on behalf, some concerned citizens filed this PIL because there was, after that earthquake, a lot of relief and materials, money were received as contribution, and they were questioning that are these things being properly managed, because there were a lot of complaints about mismanagement, right? So again, the state, they objected it, that no, you cannot take this one before the court is not the right forum, and this will be a matter of judicial overreach. So what the court said is that, the court said that no, because we have wide powers under 226, and we will oversee this one, because eventually what the court said is that it said that that parents patry doctrine, that of a welfare state, that the donors and victims has a right to seek direction for proper utilization of resources. And they said that Article 21, right, is a repository of all important rights. So they said that they, what the court did was that through this judgment, the court evolved a kind of an something called right of assistance in calamity, right, as an enforceable right for victims who are rendered helpless and handicapped due to natural disasters. So this is some a very nice judgment, and I think is one of the better judgments that I have seen over the years so far. The judiciary is concerned, and you see this one, that they also was talking about not fixing accountability also. They said that there is a need to create a separate fund for receiving these contributions, and you have to understand that these were all created before all these Disaster Management Act and all of these things came up, right? It is before that one, and they may be specially managed by the authority which is constituted for this purpose, and it is subject to periodic inspection and audit by nominee of the CAG. And what they did also, this one, that they designated a chairperson of the district legal services authorities as ombudsman in respective district to receive complaints and grievances for the quake victims. So these are, you see this one, that they were looking at the ground level, that what are the problems that people will see, what will happen, where will the people go to say that, oh, this I have this grievance or that grievance. So this is kind of they must they were concerned about, and they said after necessary investigation, bring them to the notice of the government official and agencies in charge of relief and rehabilitation program. They also said that they send a copy to NHRC, and NHRC, what they will do is that they will this for necessary action and intervention in a case where there is a violation of human rights. So they say that if this things are mismanaged, so that is again something which is against violation of the rights, and which is there according to the 12B of the Protection of Human Rights Act, right? Couple of again promising judgments. This happened in the post Uttarakhand floods. Is that this Rajiv Savara case, which is of the National Green Tribunal. So they said that no, because what they were doing was that, see, one of the thing that happened in this Uttarakhand there, so there were a lot of hydro electricity projects that were going on. So what we're doing is that they were using all these, all these JCBs to because they blast these places, the mountains, and all the marks and other things which are there, they pull them from there and throw them in the riverbed. So what happens is that for the purpose of doing this one, so the riverbed, the depth of the riverbed gets reduced, right? And so normally the amount of water that they can hold, they'll obviously hold less water, and which will overflow and will create damage. So they said that no, you have to do this one, because a lot of these things have been disturbance has happened because of these hydro power projects, right? All of these things that are happening in the immediate vicinity of the river. And they said that this compensation, that they created an environmental compensation of 20 lakhs, which is very less. But anyway, I'm more interested in the ratio. And they said that it will be paid for the restoration of the environment in that area. Again, you see this one, there was another case of the same place, right? So what they did was that in this case, the NGT, what it did was that the natural disaster, they brought it under the term accident, right? And they said that the damage resulted from the process leading to the manufacturing of power, and that's why they kind of gave a compensation of 9.62 crore, which is for property restoration, and 1 lakh for each applicant as litigation cost. So again, it's something, at least some positive points that I can see of this couple of NGT judgments. Now, the last part of my presentation is on that COVID-19. See, the COVID-19, whatever good, bad, ugly that they did to us, of course, maybe this is also some good thing that we are now so used to of this online lectures and other things, right? So thanks to the COVID-19 also, we have started this trend. So some of the things that the COVID-19 also did was that this was the first time that judiciary got involved in disaster management, right? This was a time where prior to COVID-19, these were all bits and pieces judiciary was doing. But after this COVID-19, what happened was that the judiciary was actually looking into many issues that came up. So you can see that some I have highlighted here, like for example the migrant labor problem in this INRE, the problems and miseries of migrant laborers. These are the court took a suo motu cognizance, right? It talks about the humanitarian crisis. It gave direction on free food, shelter, registration of migrants, safe transportation, Shramik trains. They were talking about streamlining. So they were kind of involved in this process because it was such a massive disaster, right? So there was their right to health, the distribution of these essential supplies and services during pandemic. This was again a suo motu case. So what happened was that they were talking about, they looked into this oxygen stock. They talked about buffers, a mandated uniform hospital admission policy, and they said that you relax that that all the procedures for getting into this getting health care and all of these things. So the vaccine, the drug protocol, all of these things, the court was overseeing these things. Again, another very important issue that about that economic relief, the wages and loan. So there was a case where this small scale industrial manufacturer association. So what they did was that this is known as a loan moratorium case. Why? Because they waived that the compound interest during this period, mandated refunds. But however, they said that we cannot completely waive off the interest, right? But we can look in things can be looked into sector specific. Then there was this ficus case where there was an MHA order for compulsory payment of wages. Now this went up before the court, and the court also said that, see, they have also a right to trade and business, right? So one of the thing is that even those people who are the businessmen, they're also affected. So they state that MHA order, right, and this encouraged negotiation between settlements between employers and employees, right? So that was another case. Again, in terms of ex gratia compensation and death certificates, so there is already this Gaurav Kumar Bansal case. So what happened was that they directed the NDMA to recommend ex gratia compensation guidelines under section 12 of the DM Act, right? And they said that let's simplify the death certificate norms, because don't get into too much of issues with regard to death certificates. Then there was that access to testing and affordable healthcare. So this Shashank Deo Sudhi case. So initially they said that all COVID tests will be free, but then they realized that it is too much to do. So then they said that okay, only this Ayushman Bharat and EWS beneficiaries, they will get this one. They were also kind of trying to balance this one, that also for the caregivers, right, and also this patients, right? They were trying to get a balance of this thing, because you see, ultimately also these are all socio-economic rights. So there is a matter of resources that are involved. In terms of prison reforms, also they said that okay, you can release some of the prisoners in terms of bail, interim relief, all of these things, right? And they also mandated regular health updates and vaccination in prisons. I was just telling you about this one, that one other thing was that virtual hearing, access to justice, court functioning. So COVID, probably this was the future, but the COVID pandemic actually accelerated this one. So they shifted to virtual courts. They issued comprehensive guidelines to all courts and subordinate courts to adopt this virtual courts for urgent matters. They also encouraged having model virtual court rules, which subsequently was adopted by many of the high courts for standardization of the process and kind of ensuring justice, right? However, there were also cases which were not so good, like for example, Alok Sridhavastav case, when there was an litigation before the court that you have these victims, right, that who are working so much, like this they require more help than what the government is doing. And the court said that no, everything what the government is doing is all good. And that even that Justice Nageshwar Rao made a comment that there are people who are working and not stopping. How can we stop it? So that was not befitting a Supreme Court judge to make this comment. These laborers, they were not working out of their free will. They were in a desperate situation, and that's what they was doing this one. So there are some of these kinds of cases also. There were also other things that I can tell you, that there was a lot of issues with regard to censorship of the of media, that the court said that no, you cannot do that one, that would be violating the freedom of speech, because many of the things the government did not want, was not liking, because some of the true incidents were reported, and they said that no, this is kind of going to be a fear mongering among people. So they said that no, we can't take this one, because eventually there is also an issue of freedom of speech and expression that are there. They also gave certain guidelines with regard to the health professionals, that their safety and security of their health professionals, because in many cases they were attacked, they were being manhandled, right? All of these things that the court actually looked into this one. So finally, we must say this one, that no more awareness is required among the legal fraternity. I thank Orissa, NLU Odisha, for setting up this Center for Law and Disaster Management. This is something which is extremely important, but less traded path. Right. So congratulations for that one. I must say from bottom of my heart of your initiative, right? And I hope that you do very constructive work in this regard. We require a lot of research in this arena, right? More so that's a more awareness need to be created. Courts, apart from these this COVID-19 things that I talked to you, and court was more or less, they were kind of kind of you can say behaving like an executive also in this matter, but it is required to take a pro-victim stand, which I don't see necessarily in the disaster management jurisprudence. It is always they're trying to give some kind of relief to the perpetrators rather than the victims. Nobody is held liable. Like for example, you take this aeroplane incident, that the air accident that happened. Where is that? No, who? Where is that? Investigations in this regard. Nobody is asking question, but such a massive accident happened. So something somewhere has gone wrong, but there is nothing that went. I'm sure there are mm, there was nothing will come out of this Goa incident also, right? So many natural disasters happen. We think that oh, it's a part of our process, right? So you see this one. That's why I said that some of the foreign jurisprudence they have shown creativity, right? State and disaster management authorities, they require serious reforms. They are in extremely bad shape, but disasters are essentially local. So if the local communities and the local authorities are not being empowered, then there is nothing that we can do, right? Emphasize on accountability that I showed in this Bipin Chandra case. COVID has brought some disaster management in the core area, but this journey has to continue, right? So that is all uh, my um, presentation, I can say.
Thank you,
Right.
sir, for an enlightening session. So if you would be okay, we can get on with the Q&A session.
Yeah, absolutely.
Thank you once again, Professor Sarkar, for that fantastic lecture. We will now move on to the question and answer session. If anyone has any questions, Sarkar, please feel free to type them in the chat box or use the raise hand.
Yes.
Yes, Kanishka sir.
First of all, I would like to congratulate Subhradipta sir for his insightful lecture that he has given. I must also congratulate him because lot of disasters in the hilly areas,
Hello.
Himachal Pradesh, Yes, yes. Am I audible?
Yeah. Now it is. Now you're audible. Yeah.
Yes, sir. My question is, sir, recently we are witnessing a lot of disasters in the hilly areas, in the hilly states, whether it be Uttarakhand or Himachal Pradesh or even recently West Bengal. And there is this debate that should development be given priority or should preservation of ecology be given priority? And this debate is unending. So I want your views on this, because even the residents of these states, the residents of um the hilly states, even they are now building 3-story, 4-story house, which earlier was not the case. And the topography is not suitable to support 3-story, 4-story house, which are built for
Hello.
yes, sir.
Yeah. See, that is exactly what I was just telling, that what happens is that whenever we are talking about disaster management, we think that we need a disaster to begin disaster management, right? That whole process is something very faulty. Like, for example, you look at a country like Japan, right? Whether it is the hills or whether it is the plains, wherever it is, right? All these hello. Yeah, I'm audible, right? Hmm. So whether it is the hills or the plains, so you can't do unsustainable development. See, I have personally visited Uttarakhand. I have seen how bad the situation is there, because they have been blasting dynamites all over, right? In the process, what they did was that this entire thing is that culminated into that 2013 this uh, this floods, right? There so much of death and destruction that happened, right? And in fact, that sometimes we say that these extreme events will happen. You can't probably control these extreme events, but when it comes to when you also have certain human contribution into that one, that these extreme events become very extreme. Like, there would be excess rainfall. Like, for example, you look at all the cities that are there. So all these cities that you do, every time it rains, right, it gets over flooded and all. Because what has happened is that the whole development is unsustainable. They have blocked the water bodies in the cities. So if there were like 20 water bodies in the cities 15 years back, today probably two water bodies are there. If there are two water bodies, of course, that where will the excess water go? So the rains, that is the reason that these water bodies, they work like absorbers, that the extra they're not there. Ecology, they create a lot of trouble. So all of these things, whatever, even in hills also, I have seen that the kind of development that they are doing, and that's why it is happening. Now and then you can see that some kind of disasters that are happening, and people are suffering, right? In fact, that very recently, that I'm forgetting the name of the case. The last month there was a case where Justice Bhuya had given a dissenting opinion about this environmental clearance. Right? You can get an first do that project and then get the environmental clearance. What good is that? If you have already done the project, then the environmental clearance becomes nothing. Right now they are saying, oh, there are 20,000 crore rupee investment that has happened, and now we have to. This would be more detrimental. So that kind of if you take that kind of argument, obviously that eventually the environment will suffer. unsustainable development will happen. Unsustainable development is unsustainable. I'm telling you, someday or other we are going to suffer. I stay in Gurgaon, right? Here the land prices have skyrocketed, right? But even the most expensive areas go down the water when little bit of rains are there, right? I myself got stuck in a 6 hour traffic jam coming from Jamia to my house, right? All of these, because where will that extra water go? There is nothing. You look at the kind of, then our that all the drains, they are all clogged, right? You please look at some of the infrastructural development that Japan has created, right? You will say that okay, they have money, but the point is that we are also destroying a lot of money by all these things getting affected due to disasters and then rebuilding them. Yeah, I hope I answered that one.
Yes, sir. Yes, sir. I got the answer.
Thank you for that answer. Any more questions? So I have a question, if you don't mind me asking.
Yeah, sure.
So you spoke about. Sorry, so I was making some notes. So you spoke about the Goa case, and then you spoke a little bit about the Goa case. Then you spoke about the Uphaar fire case, the theater case. So you spoke about a lot of cases in general. So you have a lot of interpretations regarding it, and you also spoke about the book Trial by Fire, and you also mentioned a little snippet from it of how. Neelam Krishnamurti, she mentioned of how if she would have gone and just killed the perpetrators, it would have been much more of a justice according to her rather than waiting for 19 years for the thing to actually happen. So if you look at the Goa case, the two brothers, the Luthra brothers, mentioned that it happened because of the dancer, and the other people mentioned it happened because of the pyrotechnics. Like pyrotechnicians were the cause for it. So according to all regarding all the other cases, how would you say the court will go about interpreting this case? Like what kind of
No,
liability do you think?
this is, see, eventually what will happen is that whatever the dancer is there, that the fellows who were burning those that fire, they probably court hold of them, and then they will punish them, because other people will get away with, right? So what happens is that in this case, they should have like put a 200 crore compensation to be paid by the owners, right? Take away those people who which kind of whether there are NOCs given. Now they are saying they were operating without safety certificates. We are staying, the four families we are staying, we have a lift, right? We just got our lift, the annual maintenance and the insurance done, right? So I'm trying to say is that otherwise we were worried that no, that someday somebody will come and will kind of try to do something, that why this lift is working without any insurance, without safety approvals and all of these things. So I'm trying to tell you is that we are doing it even at the very smallest level. They are running a nightclub without safety protocols, right? So see, this is a, give me one example, where there was a disaster that happened and the people at the top of the management are held responsible. See, today what were this indigo crisis, what were people doing? They were shouting at the ground staff. Now the aviation minister is coming, Reddy is coming and telling on camera that everything the top management were liable. If he stick to this version, what he is telling now, because there is a investigation committee, there is an inquiry committee which is set up by 4 people, right? And if they eventually find out, because on camera he is saying that there are a lot of unanswered question which the top management has to answer. If this is something which they really, what they are saying today, if it happens, it would be a breakthrough. right? Nowhere it happens, nowhere, right? See, every year Gurgaon is underwater. Every year, Delhi Gurgaon is underwater. We are talking about Delhi Gurgaon. We are not talking about some place in Kanyakumari or some place in Tripura, right? Delhi Gurgaon, everyone. Who is held responsible? Nobody is held responsible. It goes on. So there is this. There is a sense of impunity among perpetrators. So please read one small article by Ashish Bose. I think Ashish Bose is his name. He has written an article in EPW, Are Disasters Man-Made? So that the same thing he says, that there is nothing called natural disasters. All disasters are man-made. See, hazards, there is a difference, as all of us are related to disaster management, all of you are running in. See, there is a difference between hazard and disaster. Hazards will happen. Like there is an earthquake in a desert. So it's a hazard. When that earthquake kills people, it becomes a disaster. So the question is that how do you make this risk management, disaster risk management, that the hazard does not become a disaster, right? You remember that when the Fukushima nuclear disaster happened in Japan, right? There, imagine there that there were three disasters that took place. One was the nuclear disaster, there was an tsunami, and there was an earthquake. Earthquake, that the intensity of the earthquake was around 8. When around 8, what happened? There were some cracks in some buildings. That's it happened. Right? If that would have happened in India, God knows how many people would have died. In fact, I'll give one example from Odisha itself. See, when 1999, when this Odisha, when this one happened, that super cyclone happened, right? So there were victims around 10,000. 10,000 victims. When there was I'm forgetting the name of the cyclone, happened in, I think, 2018 or something, 17,
The
18.
2019, it was funny.
Huh. So there, what happens is that it was in few hundreds. So you see this one, that these were almost similar intensity cyclones. So from 10,000 to barely, have seen some news reports saying 50, 60. Okay, chalo 50, 60 ko hum 500 kar lete hai. Right? Real times. Right? So even if 200, 300, 400 people have died, from 10,000 we have reduced to 200, no? 200, 300. Right? So this is how this thing, because this our Patnaik was there, so he had made a lot of efforts with regard to disaster. Lot of in fact, in my book I have talked about lot of this disaster management things of Orissa, right? That how they develop these cyclone shelters, other things. There were funny incidents that happened in 1999. So there were kind of some warnings that the wave will reach a certain height. They said that 5 meters or something. So some people actually climbed on the trees to evade those waves, because they thought that, okay, if they stay above, the waves will not hit them. But when the waves came, that neither the tree was there nor the person was there. So that's, yeah. So
Thank you for the answer, Dr. Sarkar. We have another question in the chat box.
yeah. Is non-interventionist stance of the judiciary in policy matters, because separation of no, judiciary does everything. Why NLU Odisha has not got a letter from the BCI, right, with regard to attendance? What was judiciary doing in this one? Right? Was it something judiciary's domain to tell us that whether students should be allowed to sit for the exam or not sit for the exam. A ridiculous order that the judiciary has given, right? So it is about the sweet will of the judiciary, right? Justice तो होता नहीं है. सच में हम बोले कि after all these years I have understood there is nothing called justice. It is about winning or losing the case, right? Sometimes justice by God's grace happens, is just for us to read those things. You go to a court, day to day affairs, same matters are judgment comes at completely differently. So I don't see that matter as a non-interventionist. If non-interventionist would have been the right approach, then they would not have intervened in the COVID time. So COVID time, they did a lot of things. The point is that we haven't, see, one time you are saying that there is an absolute liability. Second time you are saying, no, we will not apply that one because it's a settlement, right? In one case, you yourself is evolving these principles. We are saying that, okay, let us go by the, all this law of precedent. So whatever is being decided in X case, we will employ in the Y case. I said, no, X and Y are different. So in a way, what they are doing is that they are helping the perpetrators. They are helping the perpetrators. So that's the concerning thing. Nothing will happen. I tell you, nothing will happen in this Goa case. Right? You see so many bridges collapsed. Right? Nothing. Anything happened in Gujarat just last year or year before, in 2023 or so, that thing collapsed? Nothing happened. Kolkata, there was a flyover that collapsed. Nothing happened. Right? So many bridges are being swept away in Bihar. Anything happens? Nothing happened. So that's how this whole thing is, that because there is no fear of judiciary so far this disaster management is concerned. You take it as an avoid accident, and whatever natural disasters happen, you call them that, oh, it is just like act of God. So I think that is still we are with this act of God definition.
Thank you, sir. Thank you.
Okay.
We can go on to the next question. Pradipta.
Yes, hello, sir. I was listening to your thing, and I remember that you said that how the floods and how the legislations in Assam, since I'm from Assam, gets disastrous when the time comes. And that line kind of struck a chord. So I wanted to know, in your opinion, that can the state be held vicariously liable for damages that are caused by kind of natural disasters, when it can be proved that the damages were exacerbated by poor infrastructure or lack of preparedness? Because every year when the floods do happen, the verdict that comes from a chief minister is that all the water comes from Meghalaya, since it's
That is so stupid. thing
yes,
to do.
hell, since Meghalaya is in a higher altitude, the water comes from there and nothing can be done about it. And year after year, people keep dying. So I wanted to know your opinion about if the state can be held vicariously liable.
Nee, absolutely. See, what was the CM doing that time when this floods came? He was busy in that with this Maharashtra that fraction, and he was busy in that 5-star hotel where they were all that resort that they were put up. Right. So see, the point is that some kind of damage you can not probably completely take away from that one. But there are a lot of things that you can do. In fact, very surprisingly, this that the first question was on sustainable development. That in Arthashastra there is a chapter on disaster management. Now imagine that one. That was written in 3rd century BC, right? So there is something called on disaster management. There it says that when the floods come, so they already know that there are the floods that will come. So he said you raise your structure and stay in houses built with bamboo. Why? So that the water will not stay in your house. So even if it gets flooded, it will go down. And why these floods are important? Because the floods will also bring that all kinds of soil, that the top layer soil which will be deposited in that one and will make the place fertile. So he was kind of suggesting that living with the floods, right? Arthashastra in that one quarterly was actually talking about living with the floods. Why I'm talking about things that people were thinking in the 3rd century BC. Now, in these all these things, I'll give you one very hilarious example of Assam. What happens is that every time the Brahmaputra floods, so then there would be an inspection done at the district level. So once this inspection done, so what will happen is that they will take all of these things, and I'm telling you, I have gone to villages. I can speak Assamese as well. So I have gone to villages. I've kind of spoken to them. They're quite well aware of things that are happening around. So then they will say, that, okay, we need an embankment from this one. So what will happen is that this team will give this proposal of embankment or some this kind of things to the state department. State department will give it to the home office. Home office will send this proposal and everything to the water commission in Delhi. By the time this thing gets approved, by the time this Brahmaputra will change its course. So whatever they have done now, this exercise will go down the tubes, because when it is approved, that the river has changed its course to an extent, and then that is not there. So I'm trying to tell you is that, look at Guwahati, such a messy city it is, right? So in that kind of city, even if it rains for 10 minutes, there would be flood, and that also happens with Guwahati, because there are no drains, extremely overcrowded city, right? There is no free space. So very, very bad infrastructure development in Guwahati. Of course, it will flood.
Thank you for the answer, Professor. I just had another thing to ask, if you don't mind me. You spoke about foreign jurisprudence, and you spoke about, like, Japan in general, about their earthquake, like, about the Fukushima incident of, like, with the earthquake, with the tsunami, with the nuclear reactor. So what would you recommend India to adopt from the European Union instead? Like, they seem to have a more stricter compliance when it comes to disaster management policies. So what foreign jurisprudence in a creative manner could India adopt from the EU?
I was talking about few other. See, there are cases even in South Africa also. There are cases in say, for example, in US also. What happens is that in many of these places, no, that they actually acknowledge the role of the state, right? They in many places acknowledge the role of the state. They make these people liable for this one, like if you look at Katrina for that matter, right? Because another thing is that our mm, materials, right? The literature on disaster management is also very limited. I'm talking in the terms of law and policy domain, right? I'm not talking about engineering or some other cases, in the law and policy domain. So because it is so limited, so what has happened is that even the law people have also not contributed towards this disaster management thing. So what I'm trying to tell you is that in many of these cases, no, they have hold people liable for disasters, like fire disasters, right? The kind of thing that they do, right? For example, I'll give you an example. Like in 1995, there was an Oklahoma federal building bombing, right? Oklahoma bombing. And prior to 9/11 in 2001, Oklahoma bombing of 1995 was the worst terrorist attack on US soil, right? So what happened was that they actually got a explosive laden vehicle to go past the barrier, go to a federal building, and then bomb this one. These were basically the communist people and all of these things. So that's what happened. So what happened was that after this incident happened, right, what they actually did a kind of a investigation, disaster investigation. Then they found it is that the number of people actually died because of the bomb explosion was much less than people who died because of the falling glass pieces, because of that it was a glass, building. So that is one of the reason that they found it, and they spread over a very large area. So then what the US did was that they invested a lot of money in this glass technology, and then they came up with certain things that you cannot use certain quality of glass in any kind of building construction. It's primarily the big buildings, right, which we see here all the time in malls, other things. So they invested in glass technology, and they made it mandated that you can use only this type of glasses only in these cases. So now you see that one, they have put the science and technology backed by certain rules and regulation that you cannot use that one. On top of that, these barriers that you see all the time in all these public places. So they even invested on these barriers also. And they said that you will have this certain kind of barriers, which if you want to drive the vehicle through, it will rip apart your vehicle, but you cannot cross that one. So they mandated that all federal establishment are mandated to have that kind of barriers. So you cannot have a federal establishment which does not have that kind of barrier there. So you see this one, that there is some kind of seriousness that they pursue it. Japan, if you look at this one, right, every time those people, all of us who are from cities, you will find that there is that underground water pipes. First they will put this much pipe, then after a year or so they will again dig it up, put this much of pipe, then after 2 years again they will dig it up, then they will put a little bigger pipe. Why can't they put that bigger pipe in one go? If you look at Japan, the kind of underground sewage pipes that are there, they are massive in size. They are like 10 times bigger than a human being, right? Otherwise, the kind of topography that Japan has, Japan would not have survived, right? With that kind of fault line that goes in. Even Japan also had bad experience. So in 1995, there was Kobe one earthquake happened. Right after that, what they did was that uniformly changed the building bylaws of in Japan, and they made it mandate that you have to use this kind of things in this one. What will happen is that you don't know that. See, I am sitting in a house. I don't know what kind of a steel structure that is there. They say it is all good, all good. So this is a steel structure. I am in Delhi, which is zone 4, right? So who knows that how much of steel, because they are supposed to check and give an NOC. NOC, they will sit in the office, give an NOC, build the building. So there is if the building falls today, nobody will be held liable. At the best, you will get the builder. The builder will remain in lockup for 2 days, 3 days. He will apply for bail, then he's out, and the case will drag on for 50 years. So that's the sad story everywhere.
Thank you for the answer, Professor. We have one more question. Shrishti?
Good evening, Professor.
Good
Uh,
evening.
I wanted to ask about the very serious issue that is going on in metro cities about the pollution. Very severe pollution in Delhi, even in Kolkata, it's very bad. So, sir, how do you think the judiciary can play a role to combat this issue?
And that is means judiciary. See, at least in Delhi, there is also one correction I must say. See, you see so much of discussion that is happening with regard to pollution in Delhi. Good, that is happening. In many places, it does not even happen, right? So it is at least a political agenda in Delhi, right? At least people blame, counter blame. It is there, the pollution is. You don't talk about pollution in Muradabad, in Kanpur, in Kolkata for that matter, in some places like Howrah and all of these places, right? They are extremely, even to an extent Guwahati, they're extremely polluted places, right? Some of the cities in Jharkhand, Bihar, they're extremely polluted places. Then nobody is working about talking about this one. At least in Delhi, people are talking about this one. There, people think they don't know even what AQI is, right? So in these cases also, see, whatever sometimes the judiciary will do, that you don't ply vehicles. These vehicles are kind of, you will not have this Bharat stage 3 vehicles in Delhi. 4 vehicles in diesel vehicles are not allowed. So there are certain restrictions in the timeline of the vehicles, right? All of these things that happen, at least in Delhi. In Delhi NCR, at least they are happening. In other places, it is not happening at all. See, I'll tell you that the best example of judicial intervention in pollution related case is the CNG case of Delhi. That time itself, because fortunately Kuldeep Singh was there in the bench, and he's known as a green judge, right? Because of this one, he untwisted the government to have CNG in Delhi instead of diesel vehicle. So the entire fleet of public vehicles are on CNG in Delhi. So that is the kind of intervention that the judiciary did. Now the problem is that we don't have that kind of judges. If the judges raise question, they will give some money to the judges. Are you enjoy your life and then go. This I'm sure that some judges in this Goa case will then they will say that we will give you a lifetime membership on a nightclub. You don't give any judgment. He will not give any judgment. He will find out some way to find out that these owners were not liable. Vicarious liability nahi hoga. There is no causal relationship between the people who died there and the owners. They were not in town. They don't know. So all of these things will come out. So in Delhi, the courts are talking about this. The first thing is that it is a political discussion, which is a good thing, right? At least in Delhi, it is there. Second thing is that I don't know if all the time the Punjab and Haryana government will blame Delhi will blame them, right? All these blame games are going on, right? I don't know what the Supreme Court cannot decide for such a long time. Yamuna case, you see this one, right? It is going on for such a long time. Nobody is talking about this one. So basically, there is no political will. In fact, this the 2017 notification and 2021 memorandum, which I'm forgetting the case name, that very recently, last month only, it was decided, the revision petition on that projects that environment clearance. So they have said that okay, you can build this one, you can have projects built, and then you can go for EC, that environmental clearance. So the judiciary is also not doing its job, right? Just like other people, you see that one, judges are too much respected in our society. They actually don't deserve that kind of respect, to be very honest with you.
Thank you, sir.
If we don't have any more questions, I would like to pass the concluding wrapping up part to Shriti, if you would like to take over.
Thank you so much, Professor Sarkar, for that incredibly insightful and thought-provoking lecture. Your analysis analysis of the intersection between how the judiciary operates with disaster law and management has given us all a much deeper understanding of the critical legal frameworks that can help build a more sustainable and safer future. And the connections you have drawn and examples shared have been truly illuminating. On behalf of the Center for Disaster Management and Law and all our attendees, I want to extend our heartfelt gratitude for you sharing your invaluable time and expertise with us today. And thank you everyone for joining and for your active participation. I would like to ask Professor Pegu to take over for the vote of thanks. Thank you so much.
Thank you so much. Thank you.
Today we were very grateful to have Professor Sarkar with us. And in my conversations, I remember Professor Sarkar wanted to make it as simple as possible, especially for the students in terms of the lecture today. And it was a wonderful experience seeing that students are very active, very engrossed. Of course, there were multiple questions that were asked. And Professor Sarkar also wants to be in touch with the center. I also encourage the students here. Professor Sarkar's email ID is there. Please feel free to reach out. And I also request Professor Sarkar to continue with us. And of course,
yeah, sure. It would be. I'll be also happy to do that one. That's what I was saying the first day, that I'm happy at least somebody has come, one law school has come up with a center on disaster management, and you're actively working on it. So yeah, I'm happy for that one.
Thank you so much. We also will look up to you for guidance, and I'm sure we can definitely work out something. So that we can, because it will be beneficial for all of us here at NLU Odisha to have you on board. And I just wanted to share a small news before. I mean, it's of course a big news for Professor Sarkar, because Professor Sarkar unofficially, but again has been elevated to professorship. So we congratulate Professor Sarkar.
Thank you, but let the process also take place.
No, that will have. I mean, that's just a formality now. But we are also very happy to hear the news. And in terms of our center, we are very grateful to have you here. Our faculty members are also here, and you have interacted with them. So we all are very happy. We in fact looked forward to this, and now that we have heard, we have listened to your experience in this area, and especially your references to the case laws, I think I'm pretty sure we will be having a lot of things to take home. So we are very grateful. We are very thankful, in fact, for the talk that you delivered, and especially in the manner in which you delivered, so that our students can also partake, which they definitely did. And on behalf of the center, as well as on behalf of National Law University Odisha, we once again thank you very much for taking out time to be here today, and of course to share with us your valuable thoughts on this area. Thank you, Professor.
Thank you so much. Thank you. It was a pleasure for me as well.
If it is fine with everyone, could everyone turn on their cameras for a moment so we could click a picture? Everyone who's present, if you could just turn on your camera for just a moment.
Yeah, please also share that one with me.
Yes, sir. It is done. Thank you. Thank you again, sir.
Thank you. Thank you so much. Thank you. It was a pleasure for me as well. Thank you. Okay, bye.